This week I want to discuss an interesting case with you called Bywater or Bywater Investment Limited, and it is a decision from 2019, but it is intriguing because it involves corporate tax residence, it involves puppets, and it even involves tax evasion. And the case is running to this very day. So let us see what's going on. Here is the tax decision on Bywater, among other companies, from the High Court of Australia, and it is a very complex fact pattern. So let's start by breaking it down. First of all, you have a trust company called Anglor SARL, which is for which Mr. and Mrs. Bogas, among others, are working. I'm not sure whether Anglor belongs to them, but they are involved in Anglor. And then you have in the Cayman Islands, you've got two companies which are held and managed by Mr. Bogas, and they are MH Investments Limited and JA Investments Limited. And now we come to a very important person in the plot, and that is in Australia. We have Mr. Gould, and Mr. Gould is what is called an appointor of MH Investments Limited and J Investments Limited, and that means that he can appoint the directors of these companies. And we then come to our next company. We've got Bahamas, and there we've got Bywater Investment Limited, and it is held by Anglor SARL, but it is held for MH Investments Limited, and it is run by Mr. and Mrs. Bogas, and it is making investments in shares, and it was quite successful in trading shares, and it's all about the capital gains that were realized by Bywater and its other companies, and where those gains should be taxed. So we also have then in the UK, we've got Guard Heath Securities Limited, run by a local law firm, and it has two subsidiaries, Chemical Trustee Limited and Derren Brothers Properties Limited, both also making very successful trades in shares. And then finally, and always also run by Mr. and Ms. Bogas. And then we have finally in Samoa, we have Pacific Securities Inc. holding the Hu Wang Bank Bardot, which also trades in shares and is quite successful in that. And then a minor part of its income consisted of getting money from customers of Mr. Gould and on lending that money to the companies of those customers, effectively eroding the tax basis of the companies of those companies and not really paying any tax in Samoa on the interest income earned. And even though Hu Wang Bank Bardot was owned by Pacific Securities, it had a voter suspend registered debenture, basically meaning that JA Investments could decide everything in Hu Wang Bank until the debenture was repaid. So these are the facts in a high level that we are faced with, and the case concerns all the capital gains which were realized by these companies in trading shares and whether they could be taxed in Australia or not. And now the question is, how could they be taxed in Australia if these companies are residents of Bahamas, the UK and Samoa? And the answer is that the Australian tax authorities claimed that these companies were actually managed and controlled from Australia by Mr. Gould, whereby they had their place of effective management or a central management and control in Australia. And the court also discusses the difference between the two concepts of central management and control and place of effective management, or at least it touches on the topic of the differences between these. So let's get further into the court decision. And just to clarify, if you were to ask, but hang on, Chemical Trustee Limited and Darren Bros Properties were resident in the UK, then they would have been taxed in the UK. Surely the answer, actually, one has to point out, I assume, is that they were managed and controlled by Mr. and Mrs. Borgas. So I assume that they actually claim to be tax residents of Switzerland, not the UK. A 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. So let us see what the courts actually said. And they start with the court of first instance, and it's brutal. I mean, you can see here in summary, Param J, where the judge in first instance found as follows: Chemical Trustee's real business was conducted from Sydney by Gould. Bogus rules was fake. The evidence that Gould ran every aspect of Chemical Trustee's business was overwhelming, notwithstanding that Gould had gone to great lengths to conceal that fact. The place of central management and control of Chemical Trustee was in Sydney with Gould and nowhere else. The same applied to Darren, the same applied to Bywater, subject only to the slight and relevantly inconsequential difference that Bywater was incorporated in Bahamas and did not purport to hold any directors' meetings. And then Gould owned the bank. His elaborate but ultimately unsuccessful attempts to make it appear otherwise suggested the presence of dishonesty. Every decision of consequence was made by Gould in Sydney. There was no occasion for the directors of HWB to exercise any judgment, and in fact they did not. The real business of HWB was conducted by Gould from Sydney, where its central management and control was located. And the full court then followed the court of first instance. So this, the full court, was the court of appeal. And it said the full and the current court, which is the third court, refers to the full court and says the full court found no reason to doubt Param J's findings of fact and held that no error has been demonstrated in his honour's reasoning or conclusion that each of the appellants had failed to discharge the burden of proof to establish that it was not resident in Australia. Like Param J, the full court rejected the appellant's contention that it necessarily followed from the fact that the board meetings were purportedly held abroad that central management and control was situated abroad. They kept on saying, but look where we held all our board meetings, and the court just said those board meetings were a sham. The full court agreed with Param J that the question of central management and control was a question of fact and degree, and that because the non-resident directors of the appellants never did more than mechanically carry out Gould's directions, the place of central management and control was, as a matter of fact, in Sydney, where Gould made the substantive decisions. So then we come to what the Court of Appeal itself says, right? Or the High Court. And the High Court comes with a wonderful list of old decisions, starting I think in 1870 something with Cessna Sulphur, and it goes through these decisions and it points out, you know, that central management control always has been where the real decisions are made. It's not where you hold your board meetings, right? And this is what happened in Cessna Sulphur. It happened in De Beers, which I discuss elsewhere on this channel. It happened in Koitaki and North AU, Australia Pastoral and Waterloo Pastoral. I do not know those cases. I assume they are totally Australian, but I'm unsure. Then it refers to a case called Malayan Shipping. And then it comes to Bollock and it goes deeper into Bollock. And Bollock is a British case, quite well known, and we'll talk about the facts in a moment. It discusses Esquire nominees, and then Wood versus Holden, which was another UK decision together with Smallwood. And what it says about Bollock is it says the decision of the House of Lords in Bollock is significant for present purposes because it expressly rejected the notion that a company must always be taken to be resident where its board is resident. There, in Bullock, 3 taxpayer companies were registered in Kenya, and each company had a board of directors situated in Kenya. But as the Court of Appeal had found, the directors of Kenya, the subsidiaries, did not all have access to all the documents or information concerning the companies of which they were directors. At all material times, the whole of the trading policy of the Kenyan subsidiaries was dictated by the board of directors of the parent company, which was back in the UK. And then it brings it forward to the current case, and they say Bywater, Chemical Trustee and Darren contended that Bullock was materially different from this case because whereas in Bullock the formalities of the board meetings in Kenya were largely ignored and the real business of the Kenyan subsidiaries was conducted by the board of the parent holding company in London, in this case it was apparent from the minutes that the formalities of the board meetings had been punctiliously observed. On that basis, it was submitted that in contrast to Bullock, the board of directors had not been usurped, right? Because they made all the real decisions. And the court rejects this. It says, the contention faces difficulties at several levels. First, as was earlier noticed in the case of Bywater, there were no minutes, and the only evidence of any meetings of directors was evidence given by Borgas, which Parham J rejected as untruthful. Mr. Borgas had a tough time in court. In the case of Chemical Trustee and Darren, there were minutes recordings of the board, but those minutes revealed that there was seldom more than 1 meeting of directors per year in addition to annual meetings. The minutes refer only to formal business. There is no written record of the boards of Chemical ever considering any item of substantive business or corporate policy, right? And then secondly, it says, as was earlier recorded, Borgas was simply Mr. Gould's puppet or cipher. That leaves no reason to suppose that Gould and Borgas paid punctilious attention to the formal governance of the structure or to anything else, apart from that which was considered necessary to conceal Gould's involvement in the management and control of the 3 companies. And the court then goes on to say, thirdly, even if all the formalities had been scrupulously observed, there would remain Parham J's undisputed findings of fact that the directors acted without thought at those meetings because they took no part to any extent in the decision-making processes. And then he says it's the same for the bank. They had different directors, but those directors had no idea of what they were doing. So the court then says, okay, Bullock doesn't help you, and then the taxpayer says, but what about Wood versus Holden, which is a UK case where the taxpayer won, and it was decided that the management and control of the company was not in the UK, right? And so the court discusses this, and it says the appellant's submission gains no additional support from Wood versus Holden. The reason of the primary judge rested heavily on the factual circumstances of the case, including that the only activities of the company in question were to enter into one contract to purchase shares from its parent and then to hold those shares. The primary judge considered that a case of that kind involved different considerations from a case involving the residence of a company with an active continuing business. Because so what they say here is that in Wood versus Holden, the company made one decision and that was it. Whereas if you look at these 3 companies in this case, they were trading shares all the time and they were making decisions all the time. That does not appear in this case, right? In Wood versus Holden, the primary judge spoke of the difference between exercising management control and being able to influence those who exercise management and control. A difference between, on the one hand, usurping the power of a local board, like what happened in Bullock, to take decisions concerning the company, and on the other, ensuring that a local board knows what the parent company desires the decisions to be without the parent company doing the decision, right? So at its base, that distinction appears to rest on whether the local board actually considers and makes a decision to adopt the parent company's recommendation as bona fide in the best interest of the subsidiary, or whether the local board just mechanically implements directions from the parent company because it is so directed. And what the court says is that in this case, Borgas did that with Gould's decision. He simply mechanically implemented them.